Identifying as a mom, daughter, conservative, friend, parental rights activist, Republican Party delegate, lover of freedom, conspiracy theorist, mama bear, and force to be reckoned with, this is Raising Liberty with Lindsey Beckham. Good afternoon. So I am so excited today to be here in a very special edition of the Raising Liberty podcast. I've got Michael Smith with me and also Kathryn Newman, who are the prosecutors who just wrapped up the Carly Gregg trial. And this case and this trial just kind of took the nation by storm, and it became national news because of the details in this trial. Thank you so much, guys, for being here today. And we also have former Hinds County Assistant Prosecutor, Assistant District Attorney Shaun Yurtkuran, who's going to help me out with some of these law questions that I don't know everything about. But what tell us? Are you so relieved that this trial is over with?
Yes. Yes and no. So we still have to respond to the defense motion for a new trial or J&OV, notwithstanding the verdict, meaning they've asked the judge to set aside the jury's verdict. So we will still go through the process of responding to that. And if the judge decides to have a hearing, then we would participate in the hearing. If that is denied, which we believe it would be and should be, then the case goes over to the Attorney General's office. And so then we'll be excited that we're actually done, with the case.
So, Michael, tell me, in a case like this, where a child is being tried as an adult for something like murder, do they usually have a public defender, or how do they decide who represents this child?
Right. So, I think that, and kind of piggybacking off what Kathryn said, I think a win in this case is not necessarily the best way to put it. I think
Right.
Kathryn and I, we walked out of the courthouse and talked to Court TV that Friday afternoon, and we told them really there's no winners in a case like this. You've got Ashley Smiley, who really should be in the prime of her life, and she's ended up tragically killed and murdered by her 14-year-old daughter, who, by all accounts, was very smart, was very successful in things that she was doing at school. So, and now she's been sentenced to life without parole in prison. And so it is a relief that the work part is kind of over, or at least we're getting to that point. As far as, for Kathryn and I both, this was, and we've told multiple people this was our first murder trial.
Which, by the way, highly impressed with both of you for it to be your first murder trial. Extremely impressed. You both did an amazing job.
Yeah, well, thank you very much. And Kathryn and I, we talked about this a little bit before. Kathryn and I both tried crimes against children, sex crimes, things like that, and a lot of different violent crimes before. So, yeah, this is a murder trial. It's not that different. Some aspects are different. Obviously, there was a lot more press coverage and things like that we really never see in our job. I don't think most people probably even know what we do on a daily basis. But, yeah, so, and I don't know, it's certainly the first juvenile that I had tried since I'd been there.
Mhm.
I believe. I don't know that I've tried any other juvenile since I've been there. And so you do tend to see a lot of private attorneys come in, but I think she would have had the option to get a public defender if that's what she would have wanted. I know there's been some dispute out there maybe as to whether or not she would have qualified for a public defender. Our public defenders in Rankin County and in Madison County are both some of the best attorneys who practice in Madison and in Rankin counties. I really, they do a great job. We work with them every day. And so I think that she could have gotten a public defender if she would have wanted to. I think she would have qualified. I think Judge Arthur would have appointed one to her in this case, but
And that's one thing that confused me, because it's been said that she didn't qualify for a public defender. And I didn't realize, I didn't understand how that could be, because she's a child. So obviously she has no assets. You can't say that she has so much money that she can afford an attorney. So that's one thing that I was confused about. And also, in a case like this, does the state have to take this case on and attempt to prosecute it, or is that kind of at the discretion of the state and the county?
Yeah, so I want to backtrack just a little bit, and then I'll answer that question, Lindsey. Yeah. She actually had a public defender in this case. I want to clear that up.
Oh, really?
Yes. So initially, Carly was taken to the juvenile detention center because federal law mandates that a judge see a child, a juvenile who's being tried as an adult within 8 hours of being brought to an adult detention center. So this happened in the evening. So they kept her at JDC, or Juvenile Detention Center. She was provided a attorney out there until she was brought over, and explained the process until she was brought over to the adult jail. Then she went before Judge Morrow for her her juvenile justice hearing. She had a public defender, one of the public defenders from Rankin County. So we have 2 steps over there. So in county court, we have one public defender that represents everybody until they're indicted. And so she had his services until Bridget Todd and Kevin Camp entered an appearance. So I wanted to clear that up. She absolutely had a public defender. She qualified for a public defender. She would have been provided a different public defender if she had not gotten private counsel.
Extremely interesting that now her defense attorneys are out there saying that she didn't qualify.
Yeah. So if you check MEC from the county court, you will absolutely see where a public defender was appointed to her. But sorry, back to your question about whether or not we can prosecute a case. So there is something called prosecutorial discretion for every case, right? So a case comes into our office from law enforcement. We review those cases in our office, and every district is different. We review those cases. We talk about those cases as a whole, and then we present those cases to the grand jury. So there are times where it's in the best interest of justice that a case not be presented, or a case is brought over to us and we don't think that it even meets a portion of the elements, right? So we can send those cases back. But a case of this magnitude, when you have a murder and an attempted murder, I really don't think there was ever any doubt that we were going to go forward with or without the victim's cooperation.
Yeah, that's understandable. Now, I know the defense in this case was, I guess when we see in the movies, the plead insanity. So I guess it's called the McNaughton. And Shaun, I'm going to let you go from there because this is the legal jargon I'm not real sure about.
And you guys can correct me if I'm wrong, but McNaughton insanity is that you have a mental defect, basically, and that you can't distinguish between right or wrong. And that's kind of the standard in Mississippi. And it's a very tough one to meet. We were discussing before we came on air that it's a rare thing to see someone use that. I was a prosecutor for 10 years. I can't tell you how many murder cases I've tried. It's been quite a bit. And I've never seen anybody do it. This is why I was so interested in y'all's trial, because I wanted to see it in action, because when you've been through everything from murder, capital murder, I've sought the death penalty on someone, you're like, okay, this is the one thing I'm missing out of the whole thing. And so it was really neat. What I noticed though during the trial was, and Michael, you did, I think I sent you an email and you did such a great job picking apart Dr. Clark, I think was his name, was our expert, explaining that, there was a cover up, which seems to be to just get rid of McNaughton insanity, because if you're going to cover a crime up, then you obviously know something, that you did something wrong. I mean, all of us were kids and did some things, and we tried to cover up from our parents. It's kind of the basic level that you did something wrong. So
right, and you stated the standard correctly. I mean, in Mississippi, it's whether the person knew the difference between right and wrong at the time the crime was committed, and their defense was that she had this dissociative period where she blacked out from the time that she took the dogs out whenever they came home until the time whenever she was picked up in the drainage ditch by Deputy Shack, after running from the house and shooting her.
I'm sorry, after the water awoken her.
Yeah, after
the cold water from the sewage.
Yeah, correct. And so, yeah, we obviously made motions during the trial. I'm sure everyone heard them or saw them, that we didn't think Dr. Clark testified consistent with what the McNaughton standard was in Mississippi.
I saw you do that. You made that objection right, which I think was correct based on his testimony. It seemed like to me.
And I mean, there were multiple things that we objected to about Dr. Clark's testimony. I mean, one, anyone can go back and look at his testimony during his direct examination. He never testified to the fact that his opinion was rendered to a reasonable degree of medical certainty. And we made that motion. And the thing is, and I stated on the record at the time, I understand, and the case law is kind of all over the place, but he doesn't have to say those magic words, rendered to a reasonable degree of medical certainty, but he never even said anything that approached that level, in our opinion. Obviously, Judge Arthur allowed him to testify and kind of said, well, the jury's already heard the testimony at this point. But as far as the McNaughton standard, again, we don't think he testified consistent with what the standard is in Mississippi. Every time he talked about it, and in his report specifically, he said that she could not appreciate the difference between right and wrong, which is not the standard. The standard is, did you know the difference between right and wrong? And he and Dr. Gugliano did a really good job, and Dr. Pickett did a really good job of talking about the difference between knowing the difference between right and wrong and appreciating the difference between right and wrong. And appreciation is more of a heightened standard, if you want to call it that, to where you understand the moral repercussions, kind of the community fallout that's going to surround this action. And so, we didn't think that he testified consistent with what, and then all the cover up is just a whole nother story that I'm sure we'll probably get into. But yeah, I mean, that kind of was the way we approached Dr. Clark's testimony. I think it was more of what Mississippi has termed a diminished capacity argument, which the state of Mississippi and the Supreme Court of Mississippi has said is not, they don't allow that type of expert testimony.
Well, I think what you said about the, I saw you when I was watching the trial make that objection about reasonable degree of medical certainty, which I think we all know as lawyers. It's kind of like there's one of those check mark things that when you start out as a new prosecutor, and you're qualifying an expert, and then you ask them their testimony. That's the word. That's a buzz phrase. You got to ask that. I don't know that I've ever missed that, and I'm not saying that as like I'm great or anything, but it's just the one thing I probably get right. I might mess up everything else, but I get that one right. It's like asking about jurisdiction. Did it happen in the first judicial district of Hinds County? Like you got that on your list too. So it seems to me that like that would have been something you'd ask. Now I can that you'd ask as a defense lawyer, but I can understand Judge Arthur letting it in anyway, just for the sake of the record. I had that situation in a death penalty case we tried where the defendant jumped up before the jury and said, "I did it, and I killed all these other people." And the judge I was like, "Well, Judge, now I think kind of opened the door." The judge was like, "Well, he did, but we're not going to let you get into the other murders because he had killed other people too, and just for, sometimes when you're a judge, I think you have to protect the record and make sure. And I think Judge Arthur did a good job of that. I noticed him do that very well. So
he did. And I do want to just piggyback off of that a little bit, Shaun. So, you said what the attorney should have asked. They qualified Dr. Clark as a child and adolescent psychiatrist. So right away, they keep harping on the fact that she's a child. Okay, well, in the eyes of the law, she's an adult. But Dr. Clark really didn't offer a ton of testimony that would have been different for a child versus an adult. So we talked a little bit about that a 14-year-old's brain might not be fully developed. And I think that certainly went into effect, like for the Miller factors, right? When we get to sentencing, that the jury actually did hear some statements about, a 14-year-old's brain. Dr. Pickett, however, testified that he worked in the ER and he had treated lots of children. But the main difference was Dr. Gugliano and Dr. Pickett talked about the difference in a forensic psychiatrist and what their job is. And they are looking into these people and looking into these cases to see if someone knew right from wrong. And so I think to me, it was kind of silly for them. He corrected Kevin, I guess,
I think so.
Or Bridget, I know it was Bridget that was questioning him. He corrected her and was like, no, not a forensic psychiatrist, a child and adolescent psychiatrist. And I thought, well, that's silly. But as many times as he testified, he should have also known those buzzwords. He should have come in and said, like, all of my opinions are based to a reasonable degree of medical certainty.
Law's a lot about buzzwords, there's like, we all learned that, like, there's just these certain things, to, ask I used to, in my head, always go marked and admitted in evidence. Like I always would make sure I said that. So everything would get in, and just even if you get it, even if everything was already admitted into evidence pre-marked, and I would just say it because it's a buzz phrase, that we're kind of trained to do, I think. And so it did shock me when you made that objection, like that you missed that portion, I thought.
Right. Well, Kathryn and I think we approached to have an off the record conversation with Judge Arthur, and he was basically just inquiring as to, look, the jury's been sitting over there listening for a long time. How much longer are we going to go? He wasn't trying to speed her along or anything like that. Just wanted to make sure that we let the jury take a bathroom break if they needed to. And she stated that she only had a few more questions. And Kathryn and I on the way back, Kathryn said, I don't think he's testified to a reasonable degree of medical certainty. And then she asked a few more questions and he didn't say it in those questions, or in response to those questions. And so we took a break. And as I stated during our motion, I went to the court reporter and said, hey, can you go back and search reasonable degree of medical certainty, reasonable degree, what, just all these words to make sure that he had not testified to that. And he in fact had not. And so that was kind of the basis of our motion. And again, I mean, I understand, Kathryn and I both were in private practice before we came to the DA's office. We both did criminal defense work. And I 100% agree with Judge Arthur's decision. And like I said, I think we had a valid legal basis for making our objection and our motion, but I completely understand and see where Judge Arthur was coming from and rendering the ruling that he did as well.
And so Dr. Clark was not the first psychologist that had evaluated Carly, correct? Because
That's
I was
right.
asking Shaun this last night. I said, can defense attorneys just, as an outsider that's not an attorney, can they just have however many doctors they won't come in and do and evaluate until they get the answer that they're looking for?
The answer to that is yes. And that happens in the civil side and on the criminal side. So if the state had done that, so I think you heard Dr. Pickett testify that he told us, like, my opinion is what my opinion is, whether it helps you guys or hurts you guys. I'm like, great, all we want is the facts, right? That's all we want to know. But of course, from the defense side, that was not my argument. I was like, I only want to know what helps me. So, yes, I mean, they could have as many doctors evaluate her as they want to, and we would actually never even know about it. The only reason we knew that Dr. Mark Webb had evaluated her was because over and over during hearings, they kept saying, oh, yeah, we're going to have this report. We're going to have this report. Oh, yeah, we also hired, they called him Jared, I think, but Gerald O'Brien, who, again, when I was in private practice, I used both of those doctors. I know them both well, but we never saw a report from Dr. Webb. I think that's probably pretty telling in that they went with someone else that would tell them what they wanted to hear. But again, not having a report, we don't know that for sure.
Also, there was a lot of talk about how there should have been a brain scan or some type of scan that could show that there could be a mental illness, but yet there was never any continuance filed or any type of motion to get funding for these types of scans. Is that correct?
That's true. There was definitely no motion for that. And quite frankly, we would have opposed that. I'm not sure that there's any brain scan that can tell you whether or not somebody was insane at the time they committed a murder.
Lindsey was asking me about this last night, and I said, yeah, I've never heard of that in any case I've ever tried somebody, and I would do the same thing y'all would do. I'd probably laugh in the middle of the courtroom and be like, did you really file a motion to get a brain scan? I mean, like, okay. I mean, beam me up, Scotty. Like, that's kind of it just doesn't seem like that's accepted. I don't know that any court would accept that person as an expert for something like this. So
yeah, and I mean, as far as it continues, I think anyone who practices in Rankin County knows that all three of our circuit court judges are typically highly opposed to continuances in Rankin County. I mean, Shaun, obviously now doing private work, you know that. I mean, there's a lot of attorneys who won't come into Rankin County and even practice criminal defense.
Yeah.
Because they're very much, everything is on a schedule. There's a scheduling order, and barring some really serious reason as to why a continuance should, or must be granted, they really try not to go down that route. We're very lucky in that we don't really run into a backlog of cases.
So you can't get a continuance if you need more time to read discovery or anything like that, right?
So the judge would tell you if that was your reason for a continuance that you shouldn't have gotten in the case to begin with, right? I mean, that kind of makes sense. And there are times that the state needs a continuance, right? And so Michael's right. They don't grant them to us sometimes too. They're like, get over it. I mean, a good reason for a continuance would have been if their expert was unavailable for trial. Or if, in fact, there was some additional information that we had not received that they needed ahead of time. But of course, we did not ask for a continuance. They did not ask for a continuance.
And also, what also shocked me as a former Hinds County assistant DA, this case happened in the arrest was in March, correct? Is that correct?
That's right.
And the trial is in September. Yeah, I've never seen that before. Like that's something like.
Is that because she was in solitary confinement? Were they thinking that was a reason to kind of get this heard?
So we take that into consideration, right? So it kind of depends on how quickly law enforcement gets a file to our office, on how quickly we can present it to a grand jury too. It was fast. We've had quicker. We've had some that are definitely slower. But for that reason, I mean, yeah, she's in solitary confinement, but only because, thank goodness, she was the only juvenile violent offender female that we had in custody over there. So unfortunately, we do have some males that are able to share a cell because there's more than one under the age of 18. But when we looked at it, I mean, to use the defense's own words, it wasn't a whodunit.
Right.
And so when we got the case, the very next day after she kills her mom and attempts to kill stepdad, I go over and I view this terrible video that everybody's now seen.
Mm-hmm.
And I think, what more do we need?
Yeah.
I mean, really and truly, like we're going to send this stuff off to law enforcement's going to send this stuff off to the crime lab, but like we know who our murderer is. And so at that point, we really had no idea about this insanity defense because all defendants are presumed sane in the state of Mississippi. And so we were like, okay, well, honestly, I thought this case would never go to trial. And we talked earlier about this was our first murder trial. I want to be clear. It's not the first murder case I've ever dealt with. It's just the first one that went to trial. I've also prosecuted, unfortunately, other juveniles. This is just the first one that went to trial. And so I really thought when I saw that video, okay, they're going to come up to my office and they're going to say, what's the best thing we can do, right?
Mm-hmm.
For you guys and for us. And I don't mind saying that didn't happen with them. The public defender that was handling it did come by my office and say, what's the best we can do? And I said, let's get her evaluated. And so that's the thing that's so crazy about this is they want to say, like, we didn't consider that. That was the first thing we wanted done. We're like, why would a 14-year-old do this?
Yeah.
So we're like, get her drug and alcohol assessment and get her a mental evaluation.
I was we were actually on the radio show this morning. I was talking about this exact thing where, there's been kind of maybe a public portrayal that this is kind of the DA's office going after children. I guess kind of you've seen that. And so I use an example myself. So about 12 years ago, I had to prosecute this kid that he's 17 years old and he had killed his stepfather. And the reason he did it because he came home and his mother had broken legs, arms. The stepfather beat her senseless. He had left at the time, so he wasn't there. It wasn't a self-defense or defensive other situation. But he was so mad that he found the stepfather and shot and killed him in retaliation. Now, the whole time I was thinking, man, I don't really want to prosecute this. Like I would have killed the guy too. This is my mother. So I was trying to explain to folks that it's not like y'all take joy when it's a 14-year-old. It's very tough.
No.
I imagine emotionally difficult to do things like this. And what you do is literally what I've done is living. It's not an easy thing, but it's not like you guys were out for blood on a kid. And
right.
I think you have to execute the laws. That's your job, and that's what you do. So
right. And like I said, first thing, I mean, there really was no winners in this case. And people sometimes think that prosecutors or as prosecutors that we're caught up in whether we win or lose or anything. And
sometimes.
And I mean, just so the record's clear, whether we try a single case, I don't try any case, they all plead out. I mean, I'm going to get paid the same.
Right.
And at the end of the day, we don't have some type of agenda toward any type of person that comes on our desk. I mean, whether we would have tried this case or not, we started a new term this past Monday with Judge Ratcliffe, and I have 40 cases lined up to go this. And so, I mean, the point of that being that we have plenty of other stuff to do. It's not like that we have some kind of agenda towards any one person, any one case, anything like that. And just kind of to talk about the solitary confinement deal, since that was brought up, and there's been some deal about whether or not she's going to be held in solitary confinement.
Yeah, because it was said by the defense attorneys, on a podcast that she would be held in solitary confinement until she's of age.
Until she turns 18, correct?
And sorry to interrupt you. And in the motion for JNOV, they said something to the effect of she shouldn't have to sit in an adult facility for a year while we wait on the appeal. So
right.
So what do you want?
And so I mean, and so the thing is with that is when she was back there in the adult jail at Rankin County, she had basically what we would consider an iPad. She could make FaceTime calls to her parents, or not her parents, but her family. She had obviously access to a phone where she could make calls whenever she was brought over to some of the hearings. I think the sheriff's deputies and the sheriff allowed her to actually meet with her family at times. And then, I mean, she was held in solitary, so to speak, back at the jail, but it wasn't like she didn't have any privilege. She did have privileges while she was back there. And then as far as how she's being held now, and I talked about this yesterday on Super Talk radio, anybody can go on the MDOC website now and see that she is at Central Mississippi Correctional Facility in the Youthful Offender Unit, which is where they hold all the people who are under the age of 18 over there. So she's being held with other people, not in solitary confinement. She's being held with other people who are her age. The website, you can look on MDOC website. If you go to the Central Mississippi Correctional Facility page where it talks about the Youthful Offender Unit, they offer educational classes, academic classes. They offer mental health, alcohol and drug treatment, basically any kind of things. She will receive mental health treatment in there if that's what she needs.
So that's something else that's been said, that she will not receive mental health treatment as when you're incarcerated in Mississippi. So that's not correct either.
Well, and again, even at Rankin County, the entire time she's been there, Region 8 has someone come through maybe every day or at least every week. And some of these disclosures that she supposedly made after she had murdered her mom, of course, was that she was hearing voices or that she did this or did that. And the first time that that really ever came up to a medical care provider was to these Region 8 people that she was seeing in the jail. So she was, Sheriff Bailey does a great job. And I know there's a lot of things out there about Rankin County and the sheriff's office. That the jail is a top-notch run jail back there in Rankin County. Sheriff Bailey does a good job, a great job doing that. They have access to mental health. They have access to lots of different things back there. And like I said, she had access absolutely to mental health Region 8 while she was incarcerated, and she will continue to have that once she gets to her, now that she's at CMCF.
And just to piggyback off that a little bit too, so our jail does provide that, and thankfully our board of supervisors actually has somebody contracted out. So it's not medical services through the jail. It's not like these jailers are back there giving them prescriptions and things. It's Vital Core. So I think they run through most of the Region 8 people. But she was seeing multiple nurse practitioners. She was seeing therapists. And at some point, she told both Dr. Clark and Dr. Gugliani, I don't remember if she told Dr. Pickett this also, but she said she stopped requesting therapy because it doesn't work. And so, it's disingenuous. Like the defendant herself is saying, like, I don't need this help.
I'm not insane. I don't need it.
Yeah.
Right? I'm totally fine.
Maybe the medicine's fine. The medicine's all I need, but I don't need therapy. And then her attorney's going out and saying, like, she's not getting these services. She is getting them, but she's also declining some of them.
I think a couple of things that were really shocking, I think, to just the public. The fact that she didn't take a plea deal. We thought that, I thought that was kind of crazy considering the video evidence that there is. You clearly see that she's trying to hide what she's done. So obviously she did know right from wrong. And I think another thing that was really shocking to a lot of people is the support of the family and the support of the stepfather who she actually shot and was attempting to kill. So what was y'all's take on that, on those things?
Yes. So as for the plea too, I want to clear this up because I know right after the trial, we were interviewed by Court TV and I was like, yeah, our offer was 40 years, which is true. Her initial offer was 40 years on just the murder. And we had agreed to null pros the attempted murder and the tampering with physical evidence. The week before trial, after our pretrial conference, Judge Arthur takes us all in the room, like most judges do, and says, "Hey, is there any way you probably had that happen?"
Yes,
Shaun?
many times.
Right?
Hey,
I'm not
settle this case right now. I don't want to sit through this.
Yes,
right.
I'm not telling you how to try your case either side, but don't be stiff-necked, right? State if there's some other offer you can make, get it to them. So we sit down, we have a long talk with our boss, Bubba Bramlett, great DA, by the way, great boss, better person, but he's like, okay, what do you want to do? And so we talk about it. And, the week before trial, we say 40 years, or you can plead open to murder and attempted murder and will null pros the tampering with physical evidence. So at the end of the trial, when Kevin Camp stands in front of the jury at sentencing, he's like begging them, hey, let the judge decide this. Well, we had given them that option the week before. And so again, for me, having done defense work and now being a prosecutor, I was shocked. I really did not think this case would go to trial. I watched that video. I saw the evidence. I saw the murder scene photos. I mean, for me, I don't know that you could ever overcome that burden, right? I mean, we know who did it. She appeared to know right from wrong. She did know right from wrong. I mean, she said, I effed up. Don't call 911. I'm hiding the murder weapon. I tried to hide the camera.
It's almost like a movie, really. The way you'd kill somebody, I'm hiding the gun.
Yes. So that part was certainly a little bit of a shock to us. And then I'm sorry, I don't even remember what your second question was.
And just to kind of piggyback on that too, I think so. Obviously, whenever we offered the open plea, it was to the murder and to the attempted murder. And so he's looking on the murder, he's looking between 20 and 40 years is what he's looking at. And I think Judge Arthur told both sides, he's like, I'm not really looking at the max and I'm not looking at the minimum. It's going to be somewhere in there. And so, I mean, somewhere
more like 30,
somewhere between 20 and 40. I mean, so you think that it's going to, it's going to be somewhere. So everybody hears the 40, but I mean, again, like Kathryn said, there was obviously another plea deal that we gave the week before, and I think expired on Thursday, because as I'm sure, Shaun, as well, if I spend all weekend prepping for a trial away from my family, then that offer's off the table.
Yeah, especially during football season, right? Like that's I got to do that now. Like it's off. That's another question I did have. And I think a lot of people are confused, including myself, to be honest, about life and life without parole in terms of sentencing here. So there's a statute, and I'm sure y'all know it, that if you're convicted of murder, you can petition the sitting circuit judge when you turn the age of 65.
Yes, for conditional release.
For conditional release, which is not parole. It's different. Is does this preclude her from the ability to do that?
I don't think so, because that's actually outside of the parole statute.
Okay.
And so this was a unique case, like we talked about earlier. We were, as far as I know, the first case in the state of Mississippi since the law changed in July of this year, changing the sentence for a juvenile convicted of murder. So prior to July the 1st, juvenile's life was life. July 1, they changed the statute that a juvenile convicted of murder, it's between 20 and 40 years or life if affixed by a jury.
Right.
And so we actually, Ryan Berry in our office, one of our other ADAs, and Mary Jane Lemon, our chief deputy ADA, we sat down and we were like, well, what does that mean for us? Is it life with, life without? Do we have to, like in a capital murder case, do we have to do a bifurcated guilt and sentencing phase? And so they reached out to the Attorney General's office, and they were like, hey, we would definitely recommend that you do it in a bifurcated manner because of that, and so technically it still is life. But when you look at that statute combined with the capital murder statute, which says a juvenile could get life with or life without parole, I think you make the argument that why would somebody just convicted of murder instead of capital murder get a better sentence? And so that's why we included that as one of the options, was the life with the possibility of parole.
Now, when you get life with parole on a murder, what does that entail exactly? Because I've not even encountered, I've convicted many people that got life, especially under the old murder statute before we split it into first, second degree. And it was just, they got life. And I didn't know that they could get, now, if you're talking like prior to, I think, 1995, you were parole eligible for like 10 years.
That's
I think
right.
around there. But they changed all that truth in sentencing stuff. So are you eligible for parole if you get convicted of murder? I don't know. I've not seen that, I guess.
So with the, and people hear us talking about Miller, and everybody talks about a Miller hearing all the time.
Sure.
And obviously, Shaun, I'm sure you know, but, prior to several years ago, there was a United States Supreme Court case came down, Miller versus State of Alabama. And basically in that, before, if you tried a juvenile as an adult, they were tried as an adult for murder and they got life, it was life without. And Miller basically said you can't automatically give a juvenile under the age of 18 life without parole without considering all these list of factors.
Yeah.
And so that's why whenever we went into sentencing, we included those factors in our jury instructions for sentencing that went back to the jury. I think really, and obviously I haven't spoken to a single juror. I have no idea, what they took into consideration when they went back there. But I think part of the problem is that nobody really knows what life with parole is in Mississippi.
Yeah,
I mean, from a year standpoint, I mean,
that's my point. Yeah.
I mean, is it 2 years? Is it 10 years? I mean, I think that there are other people. I know, DeAndre Dampier, the other guy that was there.
Michael Johnson.
Yeah, Michael Johnson. There's some of the other minors, the juveniles who have committed murder in Rankin County years ago, who we had to have Miller hearings on. I mean, I think most of them who DeAndre Dampier did not get life with parole, but some of the other ones who got life with parole, I don't know that they spent much more than 10 years in prison and then they were out. Yeah. And so I think the problem is, and maybe the problem with the jury, I'm just speculating here, but is nobody knows what it means. And so, is this person going to be out? And Kathryn said that in her closing during the sentencing phase, that we really don't know what life with parole is.
Yeah. I didn't know. I mean, that's, I've been doing so long. I felt kind of, I actually called, you guys know Scott Rahilio. He's kind of the guy that trained me when I was, and I called Scott. I was like, do you know what that means? He's like, no. I was like, we both were kind of like, I told him, I said, if you and I don't know what that is, that's bad. And, and so there seems to be this massive confusion. Maybe the legislature needs to look at that this session and something for them to fix, at least, to see, kind of define what this is, because it's pretty confusing.
Yeah, I agree. It seemed that way for everyone watching at home. It was like, well, what does this mean?
Yeah.
But I know it's been said since the trials wrapped that there were witnesses that the judge would not allow for the defense. Was that because they didn't submit their witness list on time, or what was the reasoning behind that?
Yeah, so that's exactly what happened. So the judge had given us a deadline of discovery that was in our possession of August the 20th. So on August the 20th, one of the defense attorneys came and sat down with myself and Ryan Berry at our office. We went through, they actually handed us a jump drive for the very first time of anything, right? So up until that point, we had been provided nothing from them.
And just to be clear, our office turned over discovery long
June
before
the 4th,
that.
On June the 4th. And it was sort of a continuing thing, right? As we realized we didn't have certain medical records, instead of the defense getting those and send them to us, I'd say, hey, I'm filing this motion. Do you oppose it? Then we'd have to get an order. Then we get the subpoena issued. Then our office would go serve that facility, and then we would get those records. So again, everything we got, we produced right away because that's what we're required to do. But on the 20th, they gave us, it was several things. It was not a witness list. I had repeatedly asked over and over and over again, via email, in person, on the phone, hey, will you guys send us, your witness list, a proposed summary of testimony? So on the 20th, one of the defense attorneys did say, hey, there's some teachers that we are going to call, but I don't know what their names are right now. And so literally on the piece of paper where she gave us discovery, I wrote names of teachers and proposed testimony. It was mentioned to us that Heath Smiley was going to provide additional testimony. So I said additional statements from Heath, anything that we didn't have. So September the 3rd, they finally file, I think it was September the 3rd, they finally file a witness list that had a couple people listed. They are arguing that Judge limited Heath Smiley's testimony and excluded both Vicki Breland, who is the maternal grandmother of Carly, so Ashley Smiley's mother, and then also, I honestly can't even remember his name, something Floyd, who was Ashley's brother-in-law, so Carly's maternal uncle. So Vicki Breland, again, was known to the defense from the very beginning. They had been at every hearing in support of Carly. They had been in communication with the defense attorneys. And so the judge then asked her, well, what's the proposed testimony? And she's like, I think it was something to the effect of, it's going to prejudice my client if you require me to turn this over right now. And so that's exactly what a willful discovery violation is, right? You can't you can't have trial by ambush for either side. And so the judge did exclude Vicki Breland. However, their expert, Dr. Clark, stated that he interviewed her. And so he actually said, I didn't rely on anything she told me for my report. So it again, I've used this word, I think, disingenuine, but it is. Like, you can't say the judge didn't let us call this person. It would have been a character witness. You cannot put on character testimony until after the defendant testifies if they choose to do so. So she didn't she wasn't going to provide any testimony. If their own expert says what she told me wasn't helpful on whether or not she was sane, and they said we're not contesting guilt, I don't really know how they could now claim that was a mistake. Same thing for the uncle. I think what it said for him was like he was going to testify about the investigation. And so we're up at the bench and the judge is like, I mean, is he certified in crime scene investigations? What's his knowledge for that? And so even if they had attempted to call him at trial, we would have objected to his testimony because it just wasn't relevant.
Did she have a second cousin or something that she didn't want to throw in there? I mean,
it's also been alleged by the defense that the stepfather, Heath Smiley, he sought out an attorney because the state and the law enforcement had asked him to change his testimony.
I can tell you, and Kathryn and I have prepped probably hundreds of witnesses together by this point. And the only thing that we ever tell any witness who comes into our office is to tell the truth. Again, going back, we have plenty of other stuff going on our desk that we don't have to rely. We do not have to rely on any witness to lie or make up testimony. And I wasn't in every meeting or anything with Mr. Smiley, but I can.
That's because we had none.
Yeah, we had none. We had none. But I can assure you that I do not believe for 1 second that anyone with Rankin County Sheriff's Office or anyone else told him to change his testimony. On top of that, there's been all this discussion about whether or not he was intimidated, and the stuff came out at the trial about law enforcement going over there and recovering some video. Whenever he found, I believe it was the garage video, he takes down the video camera, which was mounted on the motor in the garage. So, I mean, I think law enforcement just didn't see it mounted on top of the motor up there, but he takes down the video camera and he takes it into his room. According to his testimony, he had just recently purchased I think a Mac computer. So he wasn't really familiar with the cut and paste options. And so he was trying to copy and paste what was on the SD card in the camera onto his computer. And he accidentally cut and paste, which removed it off of the SD card. And so at that time he called Rankin County Sheriff's Office, said, hey, I have this video. Can you guys come over here and get it? And there is body cam footage that we have that was disclosed to the defense in this case that shows the entire interaction between these. Kathryn and I debated back and forth over whether or not to play it at trial because there was all this testimony about whether or not he was intimidated and said that he was going to be charged with tampering with evidence. Again, what the officer tells him is, look, if you come across any other evidence in this case, just call us. It's what our job is. Our job is to come collect this evidence. We don't want it to look like tampering with evidence. And again, there's body cam out there. He was not in any way intimidated or anything else in this case. And we stand by that. And the officer was simply trying to explain to him, we don't want it to look like tampering with evidence. You're already going through enough. Your wife has been killed. Your stepdaughter is now sitting in jail. Look, we're not trying to make you go. This is our job to come collect evidence. And so we don't want it to look like tampering with evidence. Not that we think you are.
That makes complete and total sense.
And they talked about holding his driver's license. Well, I mean, you can see on one, I don't think holding someone's driver's license is the precursor for charging someone with a crime. But either way, you can see in Deputy Hunter Lewis, who we put on the stand, I think was probably, our second witness. We put on the 911 call, and then we put on Deputy Lewis on the very first day. And Deputy Lewis was the first officer who arrived there, and we played his body cam footage, and you can see him go in there. But he obviously gets Mr. Smiley's ID, and he's
from the paramedic.
And he's collecting a lot of information, as you can imagine, at that time. And I think it was just one of those things. At some point, Mr. Smiley is put into the ambulance, and he's taken to the hospital, to Baptist. Right. And so I think it was just one of those things that no one was intentionally withholding his ID from him. It was not like they were trying to hold his ID so they could later charge him with something. Yeah. It was just the chaos of the entire scene, if you want to call it that, where, I mean, you have a guy shot, you have a lady laying in there who's been shot 3 times in the head. And he gets taken off by ambulance. No one was intentionally withholding his stuff, and no one was intimidating him. And
I want to talk. Sorry, Michael. I do want to talk about like our interactions with him. Right.
That was my next question for y'all. Yeah. Like, how did you guys deal with an uncooperative victim's family in this situation? I think we just set that up. Yeah.
So I said we had no meetings with him. I want to be completely transparent here. So what happens is initially he's interviewed kind of on the scene. Right. We saw the body cam footage during trial. Law enforcement gets him, and by the time that he comes in for his interview at the sheriff's department, he was represented by counsel. So he provides a similar statement to what he had provided on the scene, and similar to what he testified to at trial. At some point, again, he had decided to get counsel. So before someone is indicted, it is generally our policy to reach out to the victim and let them know, hey, this case is going to be presented at grand jury. So what I did was I reached out to his attorney at the time and said, hey, it's a little weird. We don't normally have victims that are represented by counsel. Do I have your permission to call him and just tell him kind of about the process? We didn't like bring him in for grand jury. And so the conversation I had with him was, Heath, again, I can't imagine what you're going through, kind of the things like as humans that we all say to someone who's been through something so terrible.
I thought you were very compassionate when you were questioning him on the stand as well.
And it's true. I mean, I cannot imagine what he's been through. I hope no one in this room or anyone else in the country ever, has to know what it's like to walk in and see and find your wife there and know that your stepdaughter did it. And so, there was a genuine conversation between he and I where I explained that. Where I explained to him that the Attorney General's office, like we do all our victims, the Attorney General's office has a victims compensation fund. If you decide you want some therapy, I would highly recommend it. Contact our office and we'll get you in touch with the right people. And then the only thing I said to him about not talking to Carly or anyone else, because there was still a no contact order put in place, but I knew that kind of they were getting around that by like he was contacting others and then they were relaying information to her. Not my problem, really. I mean, again, none of this is personal for us, just you're doing a job. So I explained to him that he can't actually tell anyone that she's been indicted until she's served with the indictment. There's a statute in place, Shaun, you'll know that. I mean, it's like a misdemeanor charge. Like even if I tell someone who's not the victim of a crime that someone has been presented at the grand jury, I can be charged with a misdemeanor. And so by law, we're allowed to tell the victim kind of what's happening. And so that was the only conversation I think that anyone from our office had with him without an attorney present. And then from that time on, he had opted not to speak with our office, which he has that right to do. There were 2 times, I think, before hearings where I'd asked his new counsel to step out with he and I, and we were in a witness room and we spoke. And I just asked him, hey, if you have these medicine bottles, let us know. We'll have law enforcement come pick them up. We'd love to meet with you, just kind of talk to you about what trial will be like. Kind of want to prep this. I will say this, in 15 years of practice, I've never put on so many witnesses that we couldn't talk to ahead of time. So he did not want to come to our office to testify, which is fine. The truth's the truth. All we want is the facts. We had one of the juveniles that didn't want to come before trial. And then, of course, by law, it's very strange. When somebody calls into question their mental competency, there is an evaluation order done, and the evaluator can talk to any medical provider they've had, and we can request any medical records we want to. But then you look down at the bottom of that rule, I think it's like 502 or something like that for all the legal nerds,
Right.
that says, like, it's talking about patient treater confidentiality and privilege. And then at the very bottom it says, if it's put into question by a pleading, and I think this is more for the civil side, but I took it to heart, it says you can't have ex parte communication. So despite what's been alleged in the motion for JNOV that we somehow, elicited some testimony, I was not able to talk to those providers about the treatment that they rendered. Like, I had conversations with them about, hey, we're going to send you a subpoena ducis tecum for your medical records, just as a heads up. Who's your lawyer? Where do you want it served? And then we had conversations about, hey, we need you to come on this day for trial. And so it was a little strange for us in that the victim was not cooperative. That's rare for us.
Yep.
And then again, it was sort of like the entire family didn't want us to prosecute her. And that's kind of what we talked about earlier, Lindsey, was that, like, just because the victim doesn't want it to go forward doesn't mean we don't prosecute. I mean, I said it at trial, and I mean it. I think our county is safer having her behind bars.
Yeah, I agree. And I think the world agrees. I kind of want to walk through this motion for a retrial and some of the things that are in that motion. So one of the things that was said is that she didn't get a jury of her peers. Well, obviously you can't take 14-year-olds out of school and bring them to sit on a jury. And then also it's been alleged that she received, I guess, horse therapy at some point, and this statement was made by her biological father due to her hearing voices at some point in the past. Yet wherever that seemed to have come from, no one can find it. No one knows where that came from or who overheard that being said. Yet it's been alleged that someone from a news station called Kevin Camp, one of the defense attorneys, and reported that. So what are your takes on this motion?
You're probably more familiar with it than I am. You've been kind of taking the lead on it. So.
Yeah, so I'll start with the first part, and then if you'll refresh my memory on this last part about the Kevin Gregg and the equestrian therapy. Mm-hmm. So during the course of the proceedings, again, we did, the only reason we knew who her providers were that we had done a subpoena ducis tecum for Ashley Smiley's Blue Cross Blue Shield account from 2020 to 2024 for Carly, because we knew that she was a state employee and we knew that she would have insurance through Blue Cross Blue Shield. So we knew who all the providers were from 2020 on. And to be perfectly honest, I had no idea she had had therapy before then, or we might have gone further. The defendant, however, can always request records with a signed HIPAA form, right? They can go to whoever provider they want to that they went to, and they have the ability to get those records directly. We have to have either a grand jury subpoena or subpoena ducis tecum. The equestrian therapy, we did know about. I mean, it had come out at other points. It had been talked about, I think, from the defense, but that it appeared that was ordered in Warren County when Carly's mom, Ashley Smiley, who again is our victim, that's what this is all about.
Right.
I don't want to lose sight of that. And then she was divorcing Carly's dad, Kevin Gregg. At some point, Carly's sister had also passed away. And so I cannot imagine for a 4 or 5-year-old child, you're stressed.
That's a lot.
There's a lot going on. I mean, you don't know how to convey what's going on. At 40, I still don't know that, that is something that's easy to deal with. But so she was court ordered to attend a therapy session or sessions with this equestrian therapy. And from the best I can tell, she also saw Annette Benning or Annette Bennett, and that is some records that the defense got and provided to us. Ultimately, Carly stopped seeing those therapists because they decided that therapy was not necessary anymore. There are no medical records prior to March 19th, 2024, where Carly has alleged hearing any voices whatsoever. None. They just don't exist. They've not been provided to us. The defendant doesn't have them. If they did, they would have produced them.
Right. Yes, and I completely agree. And I know there are fireworks in the courtroom, I guess Thursday afternoon, and talk of a Brady violation. So, Shaun, I know you go with that because
Sure. I think that was one of the more, I guess you would say, comical parts of the trial. And having
Not for me.
not for you, was it? Well, I mean, the Clarion Ledger had a great photograph of Michael holding
it was
his
really
computer
good.
that I think if I was him, I'd probably keep for the rest of my life. But having experienced that a lot, of course, sometimes you get defense lawyers will say they didn't receive something, and I've noticed this more in the age of advanced technology where things are done by email, or now we're all using MEC, and the older lawyers are having a harder time with it. And Hinds County does this carpool system where they'll send you discovery through, which actually I think is very efficient. But people say that, but they've always said that before all the electronic stuff, they still said they didn't get something. I had, speaking of that, Kevin Camp in a trial of my own, kind of did the same thing where it was a murder trial and he said he didn't get something. So I was familiar with that. Anyway, just exactly what was it that she said, Ms. Todd, that she was missing from evidence that she said y'all didn't give her?
So I mean, as is well known now, I mean, their main defense, so to speak, was that she was insane. And they claim that she had this dissociative state where she basically blacked out during this 2 hour or so period, and she can't remember anything in there. So, I mean, we were never, I think we came back from lunch or a break. I don't remember what it was. We came back and the defense made the motion that there was a text message between Carly and one of her friends from back in November, where Carly talks about zoning out.
Yep.
And the allegation was that we didn't turn over the text message from this friend, between Carly and this friend. Well, we had obviously gotten lots of people's phones, lots of stuff that we collected during this trial, during the investigators collected, not us. And phone extractions were done on all these people's phones. And so the friend was one of the people who the phone extraction was conducted on. And we gave the entire phone extraction to the defense whenever we turned over discovery in June
the 4th.
June the 4th.
Right.
And
just
so,
like you do in any case.
Right. Just like we do in any case. And
And
the funny thing about it is that there were so many allegations going back and forth in this case about whether or not something had been turned over or whether or not they could open something or this, that, or the other, that our office implemented this system where they had to sign for discovery every time that something was given over. So, like people said, Kathryn came with the receipts. I mean, that's what that is basically what happened. We had signed documents where they had taken this and it showed that extraction was in fact on the hard drive. Now, the problem is that, some people may or may not be familiar with the technology that investigators and law enforcement use to extract phones. There's lots of them out there, but the biggest one is something called Cellbrite.
Yep.
And you have to know how to navigate Cellbrite. I would think that most criminal defense attorneys, certainly probably all the prosecutors, know how to navigate Cellbrite. And once you get in there, you have to know where to look. And so during the break, whenever Kathryn asked for a break, we went upstairs, we pulled our hard drive, which all we did was copy it and give it to the defense back in June. We pulled up the phone extraction. We pulled up on the laptop the exact text message that she was claiming that we didn't turn over. And so then we went downstairs and we showed it to her on our laptop. We said, this is here's the phone extraction. Here's the exact text message that you're alleging we didn't turn over. And she said, well, I can't find it on my computer.
And sorry to stop you, but at that point, and I just want to say, I don't think I've ever been so mad in the courtroom.
You handled it.
Okay. I understand how that feeling.
Yes.
I
get that
talking
feeling, about zoning out, I was disassociated. I mean,
Right.
I was like, I don't remember what I said or what happened. But I do recall what Michael's talking about is we'd gone upstairs, we came back down, we had it pulled up, and I walk over to the defense table and I say, hey, here it is on the hard drive.
Right.
Molly, the court reporter sitting there, I said, do you want me to get Molly to get Judge Arthur and y'all withdraw your motion? And so I want to make sure that everybody knows that because, again, thank goodness this is outside the presence of the jury, so it has no effect on the actual trial.
Right.
And I've been trying so hard to not make it an us versus them or a personal matter. But when somebody calls into question my integrity, that is a big deal. And so even then, as mad as I was, we offered to let her withdraw the motion at that point, before the cameras turned back on. And so, sorry, Michael, take it away from
Yeah, 100%. I mean, Kathryn offered at that time to withdraw the discovery violation, the Brady motion, and defense couldn't find it on their computer. And so about that time, I was trying to help her find it on her computer at that time. Judge walks back in. She stands up and again makes the allegation that we haven't turned over. She can't find it on her computer. Well, anyone who's operated in Cellbrite any length of time, there's a couple of different search functions that you can look through. And she was simply searching in the wrong search function whenever she looked in there. So whenever she brought it over to me in the picture that you're talking about in Clarion Ledger, I basically typed it in 5 seconds, and there it was. I think she was searching for the term zoned out. And so I just typed in zone, and there it was, the same text from November that she was alleging that we had not turned over.
And I think, sorry, Shaun, they were saying that they had not received the phone extraction. Like that was her argument at first when we went over there. And so when you look at this hard drive, there's several folders that were on it, like including phone stuff. So what law enforcement had done was they had the entire extraction for each of these people whose phones they had. And then they had another folder that had printed text messages and certain reports that they had run from these phones. And so what they had looked at was only the reports and the text messages. I'm assuming, again, I don't know what all they did or did not look at, but she kept saying, I don't have that phone. And so that was like what we did before we went upstairs, and we come back down and I'm like, let me see it. We'll get out of that folder, it's right there. Well, prior to the day before we got their defense experts report, Kevin had texted me or emailed me. It was an email. And Kevin was like, hey, where are the texts between the kids? And I respond back, hey, there's actually multiple places. Like it's the subfolder with the screenshots, and that's just the screenshots from that day. And then there's a whole nother folder that has the phone in it. And so that was what was so crazy to me, was that like now both attorneys knew that they had this information and then just continued forward.
Yeah, I mean, the entire phone. I mean, the entire phone extraction, every text message. Yeah. And again, I mean, it's one of those things.
It's always a lot of information.
Yes.
Right.
It's always,
Yes. And we didn't look at all the text messages. Like, I don't know how many of you have teenagers or have looked at teenagers' phones, but there's a lot of stuff on there.
Yeah.
You know what I didn't I did see an interview with her. I didn't know, maybe it's a lack of understanding how discovery process works. And what she had said was that we never received discovery from the state. We received it from law enforcement. Well, that was, we all know that's not the way this works. The law enforcement gives it to DA's office indicts it, gives out discovery. And I think there was like, she was not understanding how that process actually worked. So,
I mean, discovery came from our office.
That's right.
That's right.
A lot of people were shocked that the judge didn't sanction her at that point, because I know he was very serious about wasting the jury's time. Mm-hmm. And I mean, of course you should be, that's your job as the judge. And that was a waste of time that afternoon. But I thought you handled it brilliantly.
Well, thank you. I felt like a rage monster.
You could see it on TV. You're not happy.
Well, rightfully so. I mean, you had every right to feel that way.
Well, and as Judge Arthur stated, I mean, as prosecutors, and Shaun, you know very well, I mean, that's a very serious allegation that we could lose our job and our livelihood and how we support our families and
license, everything.
Right.
And quite frankly, as a person, right? I mean, anyone that's known me knows that that's not my character. I'm not, integrity is all we have. It's all we come into the world with, and it's all we leave, behind. And so that was why I was so mad. Is like, hey, you could have come over to me during a break and said, hey, we have this. And we could have said, Judge, could we have a few minutes to discuss this? But instead, knowing that it's nationally televised, you say, Ms. Newman didn't give me this.
Right. Like you're just trying to like railroad a kid is what it sounds like. Right.
And then on top of that, we give the opportunity to withdraw the motion when we show that you do have it, and then basically you double down.
Well, I did have a question on that same vein with that. During the sentencing hearing, you guys were trying to introduce an exhibit. Can you talk about that, or you can't talk about that? How does that work? It's okay if you can't. I've just heard several different sources what was in this. And
so there was what I call a disturbing photograph.
Yeah.
It looked like a colored picture.
Right. Of what?
It was a goose with a knife in its mouth.
Okay.
And it said, I match energies, so you decide how we'll act. And then it had fire in the background.
Oh, wow.
And it was colored. And so I sought to have it introduced to show that, again, my argument was that the defendant still had violent tendencies. And of course, that the jury should be able to see that. And I thought that the fire was important because that was the symbol that she chose, right? Yeah. I choose fire because it's powerful, it's beautiful, and it's deadly.
So is this something she drew, the defendant drew?
Well, I think that's why it did not come in, because at a bench conference, there were some things said, and apparently it was not the defendant that had colored this or had this. And so that's why I believe that the judge excluded that.
Who did it?
I'll let your imagination run wild.
Okay, we can't go to that.
I mean, was anybody's name written on it or anything?
There was a name. There was a name written on it. And again,
we'll leave it there.
Right
with that.
Yeah. So again, I mean, I just thought that we're here on a murder case, and this is an item that our jail pulled out of her cell. I mean, so to me, I just thought that spoke volumes to the fact that this is not a remorseful person that is, she's almost making light of the situation.
Mm-hmm. Right. So that's for that purpose. And then in the Miller hearing, they didn't call any witnesses. And I heard it was because I think maybe one of them was too emotional or something to that effect to call a witness. And so generally,
the judge had said there could be no outburst, and so she took that to mean she couldn't be. I don't think that the judge meant you couldn't be emotional.
Yeah,
no, Judge Arthur says that in every single trial that we have, whenever the jury comes back. And I mean, the point of it is that, look, we have 12 people in this box who just had to go back there and make a decision that probably wasn't easy for them to make. And they're going to come out here, and half of you in here are going to be happy with the outcome, whether it's guilty or not guilty. Half of you are going to be unhappy with the outcome, whether it's guilty or not guilty. There's not going to be any outbursts. If it's guilty, I don't want to hear any law enforcement or prosecutors over there hollering and screaming. If it's guilty, I don't want to hear anything from the defendant side. And so he makes that statement, and all of our judges do, that I'm not going to listen. I mean, we've had a not guilty verdict before where the defendant jumped up and hollered because he was found not guilty, and the judge took him into custody and put him back in jail for 60 days.
That would be awful.
Yeah. I mean, so he got acquitted, but then he got held in contempt. But yeah, I mean, we didn't really know, like Kathryn said, this was obviously a very new process with the whole sentencing and the Miller hearing type deal. We didn't call anyone because we just readopted the entire record that we had already put on. So we didn't feel like we needed to call law enforcement or anybody else to come in. They heard from Dr. Pickett. They heard from Dr. Gugliano. We didn't really know what to expect from them whenever we got to that point. We kind of expected that maybe they would call some of her family members, maybe her grandpa. I mean, because at that
point, she could have called the grandparents.
Yeah, so, and it's a little weird. So, and you can probably talk about this from like a capital murder standpoint.
I was going to say that, like with I tried this case, James Cobb Hutto. He was a guy that killed several people.
There's a lot of cases, like everything cites to Hutto.
Yeah, it does. It does. I know. Yeah, it was an ordeal. It was quite an ordeal, and he killed a woman here in Jackson or in Clinton, and went to Alabama and killed another elderly woman, and then other people. It was a big mess. And yes, so during the death phase or sentencing phase, we did the same thing y'all did. We just reintroduced what was in the guilt phase. They called several people, and it was family members. Of course, he had said that he was sexually abused and those things. And then they had mitigation experts as well. So it's another thing you can do. And they had a couple of those for that. So it was that process lasted a couple days itself. Mm-hmm. It wasn't just a real quick thing. So that's what I assumed that we'd see with this case.
Shaun was shocked that there were no.
Yeah, I would assume there was some sort of mitigation expert or family member, something of that sort. I would at least called somebody like that. I think so.
So again, and I think that I don't ever want to assume what some other attorney is doing, right? I call it trial strategy. I think that's what our Court of Appeals and Supreme Court calls it. Whenever an attorney makes a decision that even though we might not agree with it, it was their decision. It was their trial strategy. I've seen it backfire where attorneys go so hard at the jury that's just made a guilty verdict, and they're like, you got it wrong. We're so mad at you. And then the jury's like, I mean, who wouldn't give their client death, right? I mean, and so I think that maybe their thoughts were, they've already seen everything. They've already heard everything. But to get back to, Lindsey, your question about could they have called those people? So I think technically you can only call people, like you can only put forward information that came out in discovery. So it did not have to be admissible in trial. It did not have to come in at the trial during the guilt phase. But it would have had to have been something that was turned over. So again, they probably could have called any of those family members that were there. I don't think that we would have objected, even if it was the two witnesses that had been excluded at that point.
That's very interesting, because that has been a big part of why they think there needs to be a retrial, is that those witnesses were excluded. And I know we're running short on time, but I wanted to ask you guys, the public's opinion was that it seemed very strange, the relationship between Carly and the stepdad, and people saw some looks or them mouthing some things. Now, I don't believe personally that there was anything going on because she shot him.
Mhm.
But I know that that's been in a lot of speculation for a lot of people. So did y'all what was your opinion on the relationship between the 2? Did you feel that was awkward or strange?
So again, every victim of a violent crime processes trauma differently.
Mhm.
And so that's what we kept talking about with Mr. Smiley, with Heath, and with Ashley's parents is we don't know what they're going through. We don't know if his reason for wanting to talk to Carly is to try to figure out the why, right? We don't really understand. I don't know that we ever will. So I don't want to judge him based off his responses. However, it is different than I think I would have reacted. I definitely saw, and people have reached out and said, oh, there has to be something. And the defense mentioned in their closing argument, well, if he had sexually abused her, this and that.
I thought it was really strange that that was even mentioned, and I thought that was just not a good look at all to even bring that up. It had not been brought up at all in the trial. Why would you even throw that out there into the atmosphere?
Yeah, I don't get that argument, but I know that I can say with certainty that Carly Gregg denied ever being sexually abused. She denied to all of her therapists, all of her counselors, to her evaluator, to our evaluators that she was ever sexually abused. Law enforcement, and this wasn't something we brought up at trial because, again, I don't know that it was really relevant, but law enforcement did find a sex toy at her house in her bedroom. And so they were like, what do we do with this? Take it to the crime lab. And so the thoughts were, if it were to come out, because if she later says he abused me, we have this one piece of evidence that we've sent to the crime lab. Well, it only came back with her DNA. And so Carly's. So again, I mean, that doesn't say he didn't abuse her, but she said that she's never been sexually abused. And then the one piece of physical evidence that we removed from the house that was sexual in nature did not have any male DNA at all present on it.
And just to be clear, I mean, Carly's phone was examined, Heath's phone was examined,
And nothing like
and
that.
there was nothing
No.
and there was
No.
nothing in there. And so again, like Kathryn said, I mean, I can't imagine the grief that he's going through and what he walked into that day. And I hope I never have to process what he's processed. And so I'm sure I can only again assume that they're all hanging on to what little bit of normalcy that, you know, and hoping that they can get back to that state of normalcy. And it's just, that's why I said from the very beginning of today that there just really was no winners in this case.
Of course. And did the state ever consider bringing charges against the friend who kind of knew that she was going to shoot Heath when he got home and didn't warn Heath about that?
No. So she, that friend was a juvenile. But there is law in Mississippi that says you have no duty to intervene if you know a crime is about to be committed. I think it's State versus Milano.
That's exactly what it is, Milano structure. That's what
yes. And so the defense tried to, in one of our hearings, try to bring that up and say, well, you didn't even charge this person. First of all, this is another juvenile, and she's come to a home, but she was not expecting to be seeing what she was seeing. She gets there, and then all of a sudden she's asked, are you squeamish around dead bodies? She sees a dead body, and Carly Gregg still has a loaded gun, mind you.
Yeah.
I mean, so I would do all sorts of things if she asked me to.
Yeah.
You know, I definitely wouldn't think, let me get out my phone and call 911 or intervene. I mean, I'd be like, I'll do whatever you say. And so practically speaking, she could have, I guess, intervened in some way. But she's not required to do so. And certainly, I mean, I don't think we would have ever thought to charge her. That friend was only being a good friend and did nothing wrong in this situation.
And just to be clear on that too. So, and this all came out at trial. I don't know if everyone kind of put together the timeline, but if you looked at the evidence and you could have put together the timeline, the friend gets there and she sends a text message to Carly at 4:58 and says, I'm here. And the friend says, that's whenever I was pulling up with my dad or I had just gotten out of the car. So she gets there at 4:58. The video from the garage, you can hear Mr. Smiley being shot at 5:03.
So it was just minutes.
Yeah, she was not there long.
The friend was only there for approximately 5 minutes. And she says she gets in, Carly's walking around with the gun. She asks, are you squeamish around dead bodies? She takes her back there, says, I put 3 in my mom and my stepdad's going to be home in a little bit. I'm going to put 3 in him.
And mind you, it's a 7-shot gun.
Yeah, it's a 7-shot.
Know what to do.
It's a 7-shot revolver. And then the friend also says that she took her around the house to show her other guns that were in the house. And so, I mean, I don't know how long that process takes, but I mean, I don't know. I don't think anybody said it, but the friend was only there for a matter of minutes.
Yeah.
And then at some point, she tells the friend, my stepdad's about to be here. You can hang out in the backyard while I take care of him. Is basically what. And so again, the friend, I can only imagine she's probably outside for a matter of seconds or minutes before Heath comes in. And then she says Carly comes stumbling out of the back, falls down, and just looks at her and says, "Run." And so that's what she does. They jump over the fence, and you see Carly in the video, and you see the friend right behind her.
And they ran different directions.
Yeah.
So that friend then goes to another friend's house and then calls her dad and is like, "Hey, come get me." And then they go to law enforcement and report it. So again, that friend did nothing wrong. I think she's probably traumatized for life because, because of what happened to her. She's certainly not a defendant.
And they did. And I mean, her dad brought her to the sheriff's office that night. I was actually at the sheriff's office because I was trying a shaken baby case during that time. And so it was probably 10 o'clock at night or so, 11 o'clock at night. And I knew that this had happened that day. And I was going to Detective Burnell, who testified in our case. He was also testifying for me in that case. So I went over to talk to him about something on the trial prep. And they said that this minor parents had brought her over. So it just kind of all came back full circle again in the end.
Well, Michael, like you said, there are no winners here. This case, there were definitely no winners. It's just tragic and heartbreaking. And I think that that's why it became national news, because the public just couldn't believe what they were seeing. So I commend you guys. I was glued to the trial, and I commend you both for putting on being such great prosecutors and being able to handle everything that came with that and prepping for this trial. So thank you both so much for being here and discussing all of this. I really appreciate it. I'm huge fans of both of yours now. And I've been talking about it to Shaun for like 2 weeks straight about just, I think it's just mind blowing, this entire case. But I commend you, and I'm just really so thankful that we have people out there like you guys that are able to do this and put the bad guys behind bars so that we are a little safer.
Yeah,
so thank you so much.
And like you said, I mean, and Kathryn, I would be remiss if I didn't give a shout out to our office and Kathryn. And we've tried to do this in anyone we've spoken to. And as you can imagine, I mean, this is a huge team effort. Kathryn and I said it yesterday, and we said it to Court TV right after the trial. I mean, we were the people obviously in the courtroom that people saw on TV, but I mean, every time we came down from break, somebody had already put water or Diet Coke on our desk. I mean, you can only imagine the work that went on behind the scenes, lining up witnesses. I think
helping do jury instructions.
Yeah, helping with jury instructions. I think just the witnesses who testified in trial were 19. I think if I'm not mistaken, which is a lot for a trial typically. And so just every single person, from the highest person in our office, our DA, our boss, Bubba Bramlett, down to the secretary answering the phones, everyone in our Madison office and our Rankin office. I mean, we could not have done this without every single person's help. And again, this is just kind of the end of our road here with this case. And I talked about this yesterday. This case will now go to the Attorney General's office. And Shaun, I know you know well about that their criminal appeals division will have to handle this case, and
they'll live with us for the next year or two.
Yeah.
You guys will live with this, let me tell you, forever, because these cases stick with you. Like I was in LA last year doing a documentary for Hulu on a case I tried in 2009. And I mean, so like in 2036, you're all going to be like, it's just going to be, it never goes away.
I hope not.
I'm just telling you, it doesn't.
And if anyone needs a defense attorney that actually does their homework, we do have a defense attorney here that sponsors the podcast. So, Shaun, since you're here, do you want to tell everyone about your law firm?
I think they heard enough already. Call me if you mess up. I'll read your file.
He'll read the file. He'll make sure he knows what's in the discovery. So,
Lindsey, can I add one more thing? I'm
yes,
sorry.
Go ahead.
We talked about our office. We talked about, but I do want to say, and I think we said this right when we came out of the trial, but none of this happens but for the investigation by the Rankin County Sheriff's Department. So I know that they have a black eye from last year. There were certain things, awful things that some deputies and another law enforcement officer in our county did. I don't want to comment on those. They're awful. They're terrible. The people that are there that works on this case and that were involved in this case, and it's a lot. I mean, thankfully we don't have a lot of violent crimes that happen like this. I think it was like all hands on deck. and processing the scene and looking for the defendant when she was on the run. I mean, the sheriff's department did a top-notch job on this case, and that's why we were able to prosecute it too. So I don't want to, and also fire and rescue, right? They have to come out to these terrible scenes. The Pafford people in the coroner's office. So again, it looks like in the courtroom it's the two of us, but there is a whole community of people that get a case to where it is to be prosecuted.
Well, we're thankful that all of those people did their jobs and definitely thankful for you guys. Thanks for coming. Really appreciate you
Yeah,
guys
thank
taking
y'all.
the time to do that.
Thanks for having us on.
Yeah, absolutely.